much. Thank you, Gillian. And thank you all for coming. I'm very delighted to be here, and I'm particularly grateful to Professor Lynch-Fannin for inviting me to speak to you today. Ooh. I can find myself here. Okay, I'm delighted to be in your beautiful country and city, although sadly only for a very short time. This is my home university that you can see up there, and that's one of the prettier parts of our campus. You can see the law school is the building very much hidden just there, which is actually not a very pretty thing at all. So I haven't got a big photo of the law school. As with most of Australia, South Australia, where I come from, is an area with strong Irish links. We had a wave of Irish immigration in the 1840s onwards, a little later than some of the other colonies in Australia. And many of them settled in an area of Australia, which is South Australia, which is north of Adelaide, called the Clare Valley. And I'll show you a few pictures of that later just to keep you awake. And so you can perhaps consider and see what they've been up to since. But my main task today is to talk about some regulatory initiatives in a couple of areas, and I'm going to focus on independence as my main topic, and then use a couple of case studies just to show how independence is used as a defensive mechanism, but in some sort of difficult and perhaps counterproductive ways. Independence has been a matter of long-standing interest to me for many years. It's a word we often throw about, sometimes without much thought, even in situations where we're relying on it. Many of you will be familiar with situations, I'm sure, in the press where something goes wrong on a governmental level, within companies, wherever it might be. And the first thing is called for is an independent review, and that's, you know, the ultimate sort of thing that's used to indicate that everything will be done properly and it will be done well. While it's become almost a slogan, independence, it's actually a little bit more complicated than it might appear at first blush. And I think it interacts and intersects with other regulatory mechanisms in ways that are complicated and probably warrant some further thought. So I'm going to start just by looking at independence for the judiciary and for directors, just to give you two case studies, and then I'm going to go back and look at what independence might mean in those contexts. And then I'm going to look at two areas where, current areas of sort of tension, where there is some conflict between independence and accountability on one case, and independence and expertise. Hopefully at the end it will all come together. Okay, so what is independence for? Let's start with the judiciary. So judicial independence is a cornerstone of your country and mine. It's seen as vital to the rule of law. And when we unpack it a bit, it's really about ensuring judges can act as an effective check on other sources of power, such as the legislature or perhaps the executive. They can protect individual citizens, they can resolve disputes fairly, and they can ensure public confidence in the system of law, the justice system. In order to make that happen, we have a fairly complex web of both law, legislation, constitutional protections, but also less certain options such as codes of conduct, norms of practice, and so on. The main planks of those different instruments really protect two aspects of independence. First is the institutional independence of the judiciary as a whole. So that's really about making sure there's security of tenure, guarantees, I think has been controversial here, guarantees of salary, security of funding for the courts to some degree, and so on. And that's really something that's been embraced in a series of international instruments, including, I've put up one example, but there are many, the UN's Basic Principles on the Independence of the Judiciary, which tries to give some guidance about what independence might mean. On the personal level, so moving to, we have these institutional protections which are about independence, but on a personal level we also have a very much less defined requirements of independence that sometimes are in codes of conduct, but are still seen as very important, and they're really about stopping judges from being partial in particular cases, partial to particular litigants or to particular points of view that are unrelated to the law. Okay, so that's the judicial, just a quick introduction to judicial independence. So moving to directors, what do we have independence for in that context? It's generally characterised as being to reduce agency costs. So agency costs are those costs that might be paid ultimately by shareholders in a company that arise where the management of the company is in control of the assets, in control of the pot of money, if you like, and may use that pot of money to further their own goals or to line their own pockets or just be incompetent or lazy or whatever. So independent directors are parachuted into the corporate board to try and stop those kinds of behaviours. That's certainly one aspect of the independent director reforms. It's probably not the only aspect as well. In some regimes, and Australia and the UK, and by analogy I think probably Ireland using the UK code, there's also a bit of a link between independent directors created that links them to small shareholders, or certainly doesn't allow them to be tied into substantial shareholders. There's also literature out there that suggests they're there for to protect the community from corporate misbehaviour. So, you know, the environmental degradation or consumer goods that go wrong. Independent directors are supposed to come in there and do, they're supermen. They're going to come in, usually supermen, sometimes superwomen, come in and save the world from you know, selfish, rational, maximising management, prioritise small shareholders, but also look after the employees and the consumers and everything. So we have a much more mixed picture of what the aims of having independent directors there might be. Despite that mixed picture though, this is a very strong plank of most corporate governance regimes across the world now, but particularly in Anglo-American type systems. And the reforms have basically taken the shape of defining what independence might mean, so saying you can't be independent if you're attached to a substantial shareholder, for example, and mandating or perhaps encouraging the presence of up to a majority of independent directors on corporate boards. Okay, and the regulatory codes and guidelines, sometimes through comply or explain kind of regimes, have tried to create some infrastructure around independence, and basically involves trying to get the right people, so choosing people for their capacity to act in an independent way, for independence of mind, but also trying to list relationships that those people should avoid. So relationships with management, relationships with substantial shareholders, relationships with customers and suppliers. So that's the sort of shape it's taken. Okay, so those are our two sort of case studies. Now coming back now, just to think, what are we actually looking for in independence? So what might it mean? And how might it fit with those two particular conceptions of independence? So independence is, as I've looked at it, I think you can break into about 4 different aspects. One is your internal capacity for independent thought, so independence of mind I think captures that pretty well. An internal ability to act independently, detached, thoughtful, competent, courageous. All those things that we would hope our directors and our judges are. I think power also has to be part of it though. there's actually no point in having an independent person on a corporate board if they have no power. And the reforms, insofar as there's embraced a majority of independent directors, are really about trying to get those directors to have some purchase on the decision making on a corporate board. So independence without powers simply becomes window dressing, and so effective independence, I think, must incorporate a potential to change the flow of events. Otherwise there's no point in having them there. So status. So part of the reforms has labelled people as independent. So once you meet the test, you're given the independent director label, and certainly judges are often commonly labelled as independent. And so part of, I think, something that we need to think about is their status, that they are separate, aloof, labelled, and that really tells us that independence is partly about perceptions. So we don't just want to think about independence as internal, it's also about projecting an independent persona to investors, to litigants, to whoever comes before them. Probably the most common conception of independence is that which is created by structural barriers. So this is where you try and list all the associations you don't want your independent person to have. And this is probably the dominant conception of independence in the context of company directors. So here what we try and do is think of all the kinds of relationships that might unduly affect a person's decision making on a corporate board. Probably the dominant ones we see there are trying to create barriers between the independent director and management. So people who have been past executives of the company have to have a cooling off period before they can be labelled as independent. It's a nice approach. It's simple, it's measurable, it does a lot of things that tick regulatory boxes. But I think without some of these other aspects, it's problematic, because it's really difficult to think of all the things you want to stop people being swayed by. You know, a list is inevitably going to be flawed to some degree. In particular, things like, to give an example, the cooling off period, which, you know, if you're a former executive, you can't be on the board as an independent until, say, you've 3 years have elapsed. It's a very bright line test, and I don't think it necessarily will capture and prevent kinds of influence that, for some people, for other people it might be enough if they were ruled off for 6 months. You know, you know, the test itself cannot actually, I think, sufficiently address the complicated nature of human processes and human decision making. On the other hand, what structural barriers are really good at is signalling the importance of independence. So if you have to do go through a test, think about various things, it probably directs your attention to what independence might mean. But also it means that you can better project the persona of independence to others who are observers. So it's really about legitimacy of a company, that you have a certain number of people who meet the test, and the test is publicly sanctioned and so on. So structural barriers are a useful way of contributing to this, but I think not the only way. So my approach is that I would recommend that you have a combination of all, and that attention be directed to all of those 4 aspects of independence to ensure that you really get a proper conception of independence, a manageable but rigorous conception of independence in place. Okay, so that's sort of the background. We've got independence, we've got these different characteristics of independence. We've talked a little bit about how they're conceived in 2 case studies, and I'm just going to move now to a couple of areas of current controversy. First is in relation to, largely to judges, although there is a developing literature about accountability and independence. How does judicial independence fit with judicial accountability? So one of the arguments that you will see against enhanced accountability for judges is that it might undermine their independence. So The traditional mechanisms of judicial accountability, and I've made a bit of a list here, are generally conceived as involving open court, so public scrutiny. So in that case, judicial conduct comes to public attention, it's in the spotlight, will lead to scrutiny, and maybe if the judge does something wrong, further steps will follow. It's a good process, it's worked for many hundreds of years, there's lots to be said for it. But I think it's a patchy process, so it works better in some cases than in others. So if you have people that the judges that are involved in large cases of public interest, then the scrutiny will be high. But lower court judges who are, perhaps dealing with the public on a day-to-day basis will not have the same degree of scrutiny necessarily in place. The appeal process, again, another useful mechanism of judicial accountability, but I would argue also an imperfect one. So if a judge engage in misconduct, it will sometimes be picked up on appeal and it's sometimes appropriately dealt with on appeal. For example, if a judge misdirected a jury, perhaps due to a misunderstanding of the law, there was a complaint about judicial reasoning, that would be perfectly appropriately dealt with on appeal. In other cases, an appeal can't be the whole answer. Sometimes appeals are not available to a party who's been wronged by a judge's misconduct. Appealing against a decision is inevitably time-consuming and expensive. This may mean that even litigants who have been wronged opt against appealing. Additionally, appeals work for both good judges and bad judges. It's a noisy signal. So even a good judge will occasionally be overturned on appeal because of genuine disagreement about what the law means. And further, even if the appeal does correct a situation where judicial misconduct has happened, then there is no systemic solution there. It provides no support for change or even follow-up as to whether the judge has got assistance or such change has taken place. And the conduct's impact on confidence in the judiciary as a whole is not addressed. Judicial removal. So in Australia, for example, a judge can be removed by decision of both houses of parliament sitting together. That's the nuclear option. It very rarely happens. I think we have put them on the fingers of one hand in Australia, which is a good thing. But it only works for the most serious misconduct or incapacity. It can only deal with the rarest of cases, and there's no process, no sanction process, because it happens so rarely. Certainly in Australia, there's no proper process for investigation of any conduct matter that leads into the outcome. So the question often remains, if there is an allegation of the most serious conduct, how is it to be dealt with? How is it to be proven? The last one I've got there is the application of general law. So this provides accountability for judges in the same way as it does ordinary citizens. But again, it doesn't address the specific standards that we hope that judges will comply with, nor does it provide a pathway for dealing with judges who've been found guilty of criminal offences. But all of these things are mechanisms of accountability that are seen to sit quite comfortably with judicial independence. But there is, I think, a level of dissatisfaction in some countries that don't have more developed systems of judicial independence, and I speak in part from my Australian experience. There's an increased interest in judicial accountability. Sorry, did I say independence in the wrong spot there? So there's an increased interest in judicial accountability, particularly in countries where there are no formal processes other than those traditional ones in place. So this is my new toy, which is an engram. You get this on Google, and you can put in any phrase and it'll tell you how often it's come up in books, Google books in the last whatever period you choose. But this shows the interest in judicial accountability and how it's increased since sort of the 1980s, I guess, right through to 2000. So I think there is increased interest in this, and so I think the question remains as to whether those traditional mechanisms are enough. And these are some of the reasons why we might want to look a little further at accountability mechanisms that can sit with independence. So the problem of judicial misconduct and incapacity should not be overstated, but neither should it be overlooked. Judges do engage in misconduct and judges do become incapable. Further public interactions with the judiciary will inevitably lead to complaints, and some measured way of dealing with this is a good idea, in my view. So this is just a little bit of a picture of a couple of accountability mechanisms that are thought to, well, at the top here, this is a fairly new one in England and Wales. So this came in 2006 with their constitutional reform. Basically, it's a system which involves cooperation between the executive and the judiciary. So the top two at the apex, the Lord Chancellor, who is a member of Cabinet, and the Lord Chief Justice, who's head of all the judges. They have an investigations office that investigates, receives, dismisses, advises on complaints, and then they have a review body, the Ombudsman, which is independent. So that is despite it's quite complex, and I won't go into it too much because I know time is short, but it's quite complex conception, it seems to sit quite well with judicial independence. Australia's been much more conservative, and I'll just perhaps talk about my home state, which has nothing apart from the parliamentary removal processes and the appeal process we talked about before. And the alternative is that if a complaint is received about a judge, then it goes back to the head of jurisdiction, who's asked to deal with it informally. And the head of jurisdiction in our jurisdiction has no power to visit any sanctions on judges or even to restrict their sitting. So basically it involves the head of jurisdiction having to try and claim some power he or she doesn't have in order to try and intervene in a judge's behaviour. So I suppose the difficulty that we're approaching here is what are the real risks that might be involved, identifying the real risks that might be involved to judicial independence if you have a proper accountability system. So this quote here is, I think, saying that independence cannot withstand a proper accountability system, and I think that that's got to be wrong. Without proper accountability, the public faith of individual litigants and the wider public could be damaged. But we do need to make sure that we retain what we need of judicial independence while creating our accountability mechanism. So we need to design it in ways that minimise the risks of political interference, which is really about making sure that judges can stand aside from the executive and the legislature. And we make sure that we don't undermine the capacity of judges to withstand pressure from individual litigants as well. So here we enshrine judicial independence because it's useful for making sure that judges make fair and impartial decisions. It's also a way to support the high level of public regard for the judiciary. However, independence is not the only value at stake in the judicial discipline process. Accountability also plays a role in shoring up the institutional integrity of the courts and therefore supporting independence. So in fact they can feed back into each other rather than being the trade-off that they're often portrayed to be. Okay, the other things you have to watch, and I won't go into these in any detail because I think they're really just about crafting independent accountability systems properly, is that you don't want to undermine the privacy of individual judges or litigants, and you also don't want to hand the system over to vexatious complainants, which are a feature of most of our systems. Okay, this is your light relief here. This is the Clare Valley, where all the Irish people live. So it's a wine growing area, it has beautiful wine. It's about 2 hours north of Adelaide, and perhaps doesn't look very much like your County Clare, I don't think, but a nice place to visit. Okay, so that's my one area of tension. We've got accountability, the argument that it can't sit with independence, that they fight against each other. Actually, I think they reinforce each other. My second one is turning now to the company area. The area of independence and expertise. Now, as I said, we've had long-standing regulatory reforms which have tried to prioritise independent directors of companies. And so we've put more and more independent directors on company boards. I think this is a common feature of many regulatory systems. Since the GFC, we're seeing a lot of critique of that position. And I've just put some of the authors that have attacked this particular approach as potentially undermining or perhaps prioritising independence without thinking about what other characteristics we want our directors to have. The thing that's been commonly thrown up is the area of expertise. So the idea here is that, again, you cannot have independence with expertise. Independence shuts out any other virtues. And I've just put a paragraph here from a scholarly paper which makes that argument. So where you have independent directors, they're less likely to have an in-depth knowledge of the internal workings of, say, the banks, for example. Though independence is seen as a good thing, greater independence may be a bad thing because a more independent board would not have sufficient expertise to monitor. So this critique of board independence has reached, I think, at least in academic terms, fever pitch. It's arisen in particular from the evaluations of board performance in banking and other financial institutions, and suggests that independent standards possibly discourage or trade off expertise for independence. It's argued a majority independent boards have a limited ability to understand and contribute to strategy or effectively monitor performance in complex businesses. While the scholarly discussion is focused on the financial sector, because that's, I think, where most of the problems seem to arise in the GFC, it seems plausible that the importance of expertise is not confined to one sector in particular. So is the trade-off really that simple? Expertise is not, I think, a one-dimensional idea. It's complicated, as anyone of you would know. I think expertise requires long, diligent study, practice, and careful, thoughtful reflection. These are some of the definitions of expertise I've pulled out. Experts are wonderful things if they have all those, I think. What I've tried to do is just think about expertise in particular in relation to corporate boards. So what kind of things do we want our directors to have? And I want to put forward an argument that we need three things from our directors. One is domain-specific expertise. So that's about whatever their primary domain is. It could be law, it could be accounting, it could be mining, it could be whatever. So some domain-specific expertise that's relevant to the business of the company. We also want them to know the company and the sector in which they're operating. So that's really about understanding the context in which they're working so that they can make proper decisions. The nature of the company's business and its state's clearly important information. Most directors, from my empirical work, seem to engage in a due diligence process before they take up appointments, which might involve talking to those inside the company, including other members of the board. But also publicly available materials might be drawn on to give them firm-specific knowledge. For those directors who've worked or are working in the same or related industry, there may already be a degree of knowledge. Inevitably, however, for independent directors, firm-specific knowledge will predominantly be developed post-appointment. The third one I've got there is director craft. Understanding the responsibilities associated with a board position would be a critical basic competence. And I think we're seeing this come through in the cases now. Some courts have emphasised the importance of directors having this understanding and imposed liability on directors who fail to meet their responsibilities. It might include expertise in governance, in small group decision making and reading proposals and financial statements, understanding business structures and so on. So what do our regulations say about expertise? So these are the Australian ones. We've got a bit of a change. This has just come in where boards have to disclose their skills matrix. So not for individuals but for across the board. And they have to in evaluations they have to consider skills. For the UK Corporate Governance Code, we've also got, the audit, the one there which for the evaluation one is from the UK Code. The Audit Committee also, there's a bit of a push for domain-specific expertise in both instruments. So that's really about accounting or financial expertise. So we're seeing, I think, some search for domain-specific expertise in our regulatory instruments, but not so much focus on firm-specific expertise, which I think is the real problem for independent directors. The courts are also getting into the picture here, looking at the competence of directors. So these cases, Australia has quite a lively jurisprudence on the duty of care, skill and diligence, partly because we have public enforcement of directors' duties. So it's not up to just shareholders to pursue directors or liquidators or the company itself to pursue directors. Company regulator, ASIC, is able to prosecute company directors if they breach their duties. So we have perhaps a more lively jurisprudence in this area than some other jurisdictions do. And in complicated ways, the UK seems to have picked up on some of that. So we've got this sort of influence coming through from some Australian cases in the UK duty of care, skill and diligence as well. So in Australia we have a number of cases, and really our cases have our jurisprudence in this area has come from the insolvent trading cases. So we have a duty to avoid insolvent trading, and those cases really pushed directors having to have skills like ability to understand financial position of the company, essentially. I've got a couple of quotes there from a sort of landmark case in 1995 and also a more recent case that really shook directors in Australia. This was ASIC and Healy was a case where the directors were pursued for signing off on the financial statements when some of the liabilities in the financial statements were misdescribed as non-current liabilities. So $1.3 billion of liabilities were misclassified on the financial statements, and the board just didn't pick it up and signed off as that it gave a true and fair view of the position of the company. And the judge said, no, it's not good enough. It's not. You need to have a basic understanding of accounting standards. You need to be able to read your financial statements. There was clear evidence that the board actually did know that they were current liabilities. They just hadn't picked it up in the financial statements, and they were all found to have breached their duty of care as a consequence. Penalties were not terribly high, particularly for the independent board members. So independent board members were given a period of disqualification and no fine, but the executive board members were given a fine as well as a period of disqualification. So the English cases, you'll probably be familiar with some of those. I think that some of them are fed through into the Irish jurisprudence as well. And both countries, I think, have developed from a subjective test of competence to looking for kind of director craft expertise, abilities to read financial statements, to understand what their role is as director, and then obviously to perform that role. So, and I've just put some of the case examples that demonstrate that there as well. I know I'm going over time. So just in conclusion, we've got these two areas where there's tension between independence and other virtues. And I think that we have to remember that often in regulatory terms it's not a black and white picture. What we want to do is make sure we retain enough independence to give directors, judges the detached view that they need, whilst also making room for things like expertise, which are equally going to be important on corporate boards. So we need to understand the nature and purpose of independence and not permit it to drown out other values. Independence is no silver bullet, no magic word, no simple solution. But it's also not necessarily something that rules out other virtues. It's not a problem necessarily either. So a more thoughtful conception of independence can coexist with a thoughtful conception of both accountability and expertise. What we should do is keep returning to why we need independence and understand the way it intersects with these two other values. Make sure we have clear conceptions about how those values fit together in law and regulation and practice. And my bad pun there is that we need to guard against real risks without losing other virtues.